Yes, Mr. Peter. Oh, yes.
Did say that the right in the convention to vote in legislatures did extend to the EU Parliament. The reference there is page 2064.
Thank you very much.
And referred to a case that said that the rights didn't extend to local elections.
Yeah. Yes, Mr. Giovanetti.
So, because before the short adjournment, I was dealing with the interpretation of section 10.2a, and I had started addressing the principle of legality and just looked at the rationale underpinning that. The second point I'd make about the principle of legality and how it can assist in interpreting 10.2a is that, of course, it's only engaged when one's dealing with an interference or an abridgment of a fundamental or constitutional right. And we say it's for the appellants to establish that this is such a right. And it's fair to say there is no clear test for that. One of the approaches that's been suggested by my Lord Sales, in fact, in some articles you've got it in your appendix, I think at tabs 53 and 54, is to ask, how does Parliament regard the right in question? We think that's a very helpful approach, respectfully. It's a useful indicator here that where local government elections are concerned, as compared to parliamentary elections, which are all regulated by primary legislation, Parliament's conferred power on the Secretary of State to lay down the procedure in secondary legislation, and that's just an indicator. We've seen section 36 of the 1983 Act, which you've got at EF page number 1439 and 1440. So where local elections are concerned, the starting point is the parliamentary election rules in Schedule 1 to this Act, but by section 36(2), they are subject to such adaptations, alterations and exceptions as seem appropriate to the Secretary of State. That's a very wide power. And then by subsection 3C, for example, the Secretary of State may by regulations make such provision as he thinks fit in connection with the combining of polls at any elections under this section, including provision modifying representation of the people acts in relation to such elections. Those provisions are specific to local government elections and not obviously applicable to parliamentary elections. But it's fair to say that we accept, of course, that this is an important right, albeit it's a qualified statutory right subject to the satisfaction of statutory preconditions and procedures. So only a person who's entered on the register is entitled to vote. And the right to vote is to be exercised in accordance with prescribed procedures, which, as we've seen, have long included identification procedures. So in a way, it's almost circular. But in determining whether the principle of legality applies, it's not just the nature of the right that's relevant, but also the nature of the restriction or interference. And as to that, what section 10.2 allows is the piloting of revised procedures, subject to careful safeguards, including involvement of the local authority and the Electoral Commission, in order to ensure that proposed changes can be evaluated thoroughly before being adopted. And that brings me to what I say is the key point in relation to the principle of legality, which is that even if it's engaged, it doesn't make any difference to the outcome in this case. And that's because Section 10, properly understood, is a protection mechanism. It demonstrates that Parliament has understood the importance of the right to vote at local government elections and protected it for the future by providing a piloting power subject to safeguards. It's a sui generis scheme enabling careful assessment before any changes are made. So even if it's engaged, the principle of legality doesn't justify a narrow reading of Section 10.2a. Parliament's deliberately enacted a flexible, forward-looking scheme intended to provide a continuing mechanism for piloting such changes to voting procedures as might be contemplated going forward. It's not a one-off provision. And we say that Parliament cannot have intended to exclude pilots that involve different procedural requirements, even if some individuals might find those more onerous. If 10.2a were limited in that way, the utility of the entire scheme would be severely impaired. So, for example, it could be said that electronic, telephone or internet voting were less convenient and less accessible to some people. But in fact, what one's doing is anticipating the very purpose of the pilot scheme, which is to enable the Secretary of State and the Electoral Commission in making its recommendations, and indeed Parliament when we come to the affirmative resolution procedure, to know, in fact, whether it has been more onerous, and if so, for which groups, and what can be done to address that. So the pilot schemes might be amended. My learned friend's given the example of transgender people who might find it difficult to meet certain identification requirements. Well, the best way of assessing that is by having a pilot scheme and having the procedure for the local authority to assist the Electoral Commission, all of which is laid down in Section 10.
Well, by virtue of that argument, are you saying that persons who might be disadvantaged or have a difficulty with some of the piloting schemes, whatever they may be it remote or voter ID, have a voice in terms of permanent change?
Precisely, yes. Yes.
Where would that voice be, or how would that play out?
Could I just go back to Section 10?
Yep.
And it's the reporting provisions that we were looking at. So if you go to EF page number 1691, 10.6 provides that once any elections in relation to which a scheme under this section applied have taken place, the Electoral Commission shall prepare a report on the scheme.
Yes.
And then by 6A, the report should be prepared by the Electoral Commission in consultation with the authority concerned, and that authority shall provide the Commission with such assistance as they may reasonably require in connection with the preparation of the report, which may in particular include the making by the authority of arrangements for ascertaining the views of voters about the operation of the scheme. So yes, and I should have emphasised that it's not just the Commission and the local authority. There is specific provision to take into account the views of voters about how the pilot scheme has operated.
Thank you.
So can I turn then to the next argument, the appellant's advance, as to why a narrow construction of 10.2 is to be adopted, and that's by reference to the principles applicable in construing Henry VIII powers. And our answer to that is very similar to our answer to their arguments based on the principle of legality. It's only a principle of construction, and even if it applies, whether a narrow construction is justified will depend on all of the relevant circumstances. And we say it doesn't apply here because sections 10 and 11 are not a conventional Henry VIII power as that's generally understood. They create a sui generis statutory scheme incorporating the assistance of the Electoral Commission, a report by the Electoral Commission, recommendations by the Electoral Commission in section 11, as well as my lady quite rightly says, provision for ascertaining the views of voters. The examples that have been given as to where the power could be used in relation to primary legislation, so the secrecy of the ballot or voter registration, aren't really at issue in this case, because the principle at issue is whether section 10.2a is sufficiently broad to accommodate revisions to the procedures for voter identification. And as we have seen, all of those provisions are in secondary legislation. But finally, we say that even if the principle does apply, it doesn't require a narrow construction here. There isn't sufficient doubt or ambiguity in the words used. And as we've said in relation to the principle of legality, no viable narrow construction of 10.2a has been identified. The next point we'd like to address is the suggestion that a purposive construction of 10.2a should be adopted. And could I just start by making the point that where 10.2a is concerned, the question of a Padfield purpose doesn't arise. Because that relates to the purpose for which the power is exercised, and the power is in 10.1. All that 10.2 does, and in particular 10.2a, is define what is a scheme falling within section 10. And that's a question of objective construction. Insofar as the question of a purposive construction even arises, we say that a purposive construction is intended to be permissive. The point is to ensure that an undue focus on the minutiae of the language doesn't leave the identified mischief unremedied. And could we turn briefly to Quinta Valle, which we have at volume 5 of the authorities bundle. I'm sorry, I know you have them all electronically. Good, at least it's helpful to Mr. Peter, if not to the court. I'm also working from hard copies. So it starts at EF 3578. And could we pick it up at 3583? paragraph 8, the basic task of the court is to ascertain and give effect to the true meaning of what Parliament has said in the enactment to be construed. But that's not to say that attention should be confined and a literal interpretation given to the particular provisions which give rise to difficulty. Such an approach not only encourages immense prolixity in drafting, since the draftsman will feel obliged to provide expressly for every contingency which may possibly arise, it will also, under the banner of loyalty to the will of Parliament, lead to the frustration of that will, because undue concentration on the minutiae of the enactment may lead the court to neglect the purpose which Parliament intended to achieve when it enacted the statute. The court's task within the permissible bounds of interpretation is to give effect to Parliament's purpose. But if one applies that logic to section 10, one might focus on the fact that Parliament hasn't explicitly made reference to identification procedures. But that's not the right approach. You've got to look at what sections 10 and 11 are intended to achieve in the round. And I'm sorry, you're probably tired of hearing me say this, but they're intended to provide a protective mechanism designed to ensure that potential proposed changes are made on the basis of the fullest assessment and a solid evidence base. So actually, a purposive construction in the present case tends to support a broader interpretation, not a narrower one. And in particular, principles of a purposive construction aren't a basis for reading the words more narrowly, so as to only apply to a mischief specifically identified at the time of legislating. And in that regard, it's helpful, we'd suggest, to look at the Palestinian Solidarity case, which is in the same volume, Authorities Volume 5, tab 34. I think it starts at EF 3551. And if the court turns to EF 3572, could I ask the court to read paragraphs 64 and 65?
I think it's right to point out this is in a minority judgment, isn't it?
Oh, I'm so sorry.
I think Lady Arden and I were certainly dissenting in the result. Doesn't necessarily mean these statements are wrong, but I think one
No,
bear in
absolutely.
mind.
There was something else I'd marked up, and I'm so sorry, it seems to have fallen off my note. Could I just have a moment?
Paragraph 65 seems to be on safe ground anyway with Spaff
I would
Home.
have thought so. I just can't remember if the majority even referred to Maunsell and Dolins and Spaffholm. I just can't remember, sorry.
Well, thank you very much for trying to. If I find what's fallen off my note, I'll try and take you back to it.
In a sense, Spaffholm and Maunsell and Dolins, just stand as authority themselves. You don't need Lady Arden and me reading them out to give them authority.
Yes, sorry, I think that's very helpful indeed. I'll move on it, if I may, to my next point, which is what is the mischief? And we say that the appellants here define the mischief too narrowly in any event. If one turns to the appellant's case at EF 130, paragraph 119, their starting point is that the Court of Appeal held that the statutory purpose of Section 10 of the 2000 Act was to modernise electoral procedures rather than to facilitate and encourage voting and make voting easier. And then they go on to say that conclusion was wrong. If one looks at what the Court of Appeal actually said at EF 242, which is in the same volume, at 58, they accepted that the immediate prompt for this part of the legislation was a perceived decline in voter participation, and that Parliament wished to address that. However, the materials to which the court was taken don't indicate that Parliament was not interested in any other features of the voting system. It seems to me that it was anxious to promote modernisation of the system and its integrity. We've looked at bits of the Home Affairs Committee report and the Howarth report, and with respect, we say that part of the appellant's error is to focus on the specific pilot schemes that Howarth identified. But firstly, the Howarth report was in no way suggesting that those were the only pilot scheme proposals for which provision should be made. And in particular, insofar as you find it helpful to look at Howarth, if you turn to EF page number 500, which starts with paragraph 314, in fact, it'd probably be more helpful if we pick it up the previous page, 499. So at the end of paragraph 3.1.2, they record that in their view, now is the time to consider a fundamental modernisation of the electoral process. At 3.1.3, preferred approach being to move forward in this key area through piloting, enabling different arrangements to be tested in discrete schemes and then fully evaluated before deciding whether it's safe or sensible to extend their application, recognising that the approach can't be simply theoretical but it's got to involve real elections and real voting. At 3.1.4, they suggest that the development of pilots, picking it up on the third line, should allow schemes to be devised in collaboration with local authorities, which is precisely what the scheme does. At 3.1.5, it's their view that piloting can't be a matter solely for local authorities, and then picking it up on the fourth line of that paragraph, what is required is a centrally managed and coordinated programme which allows and encourages initiatives to arise from the local authorities themselves. And it's clear, we say, on a reading of this report as a whole, that the pilot schemes that they identified were not intended in any way to be exhaustive. They were just some suggestions for pilot schemes that might be useful. But primarily the intention of Parliament is to be derived from the statute, and the statute doesn't in any way restrict the pilot schemes to schemes that will encourage voter turnout or facilitate voting. It's a much broader scheme which is intended to encompass addressing any concerns that may arise in the future. And in that regard, while it's been suggested that there are no concerns about voter fraud, I'd take issue with that. It's fair to say that that was not a particular concern at the time of the Howarth report. But if we're right in saying that the purpose of Section 10 and 11 is intended to enable concerns arising in the future to be addressed, there's plenty of material to demonstrate that by the time of these pilots there were concerns about electoral fraud. And I'm just going to refer you to one document in the bundle, and that's the January 2014 Electoral Commission report. It starts at EF page number 547. And all we'd invite you to read is the foreword at EF pages 549 to 550. Foreword starts with electoral fraud is a serious issue. The third paragraph, second sentence, where vulnerabilities remain in our electoral system and where these could be exploited by those who want to commit fraud, further action is needed. The sixth paragraph, perceptions of fraud can be as damaging as actual incidents of electoral fraud. Voters must be able to have confidence in the system, and in our review we've looked at what more could be done to ensure they can. The next paragraph, first, there is no doubt that in some areas of England there is a history of concerns about fraud, and in some cases fraud has been attempted and detected. And then finally, over leaf at 550, finally, we should move to a system where voters are required to produce identification at polling stations. We gathered substantial evidence during our review that the lack of a requirement for ID is both an actual and a perceived weakness in the system. And that really ties in with the point that was being made this morning during my Learned Friends submissions, that having a safe, secure, effective system is in itself something that is likely to improve public confidence and encourage greater participation. As to Hansard, that's relied upon in the appellant's written case. You weren't taken to it in oral submissions, but the short point we'd make about that is that nothing that they've pointed to in Hansard excludes or limits pilots of different forms of voter identification.
And my recollection is there was nothing in Hansard that fell within the three tests in
No.
Pepper and Hart.
No, we say there isn't.
Particularly the third test, where you have a statement which is clearly on the question, the issue of interpretation that the court has to decide.
Yes, precisely. And of course, Hansard's relied on, again, when we come to the purpose under section 10.1, and I'll say something again briefly about it, if I may, there. So can I move on to that now, if that's of assistance? That's all I was going to say about 10.2. But I was going to move on to deal with the power in 10.1 and the purposes for which that power may be exercised. So our case is that the section 10.1 power may be used to permit proposed changes to local government electoral procedures, as formulated from time to time, to be tested with a view to improving those procedures and addressing concerns that have arisen and been identified in the public interest and on an informed basis. We address this in our written case at paragraphs 106 to 113. That's EF 180 to 183. But I wonder if I can just highlight briefly some specific points there. It would be helpful to have section 10 open again. That's at EF 1690. So what 10.1 provides is this: where a relevant local authority submit to the Secretary of State proposals for a scheme under this section to apply to particular local government elections held in the authority's area, and those proposals are approved by the Secretary of State either without modification or with such modifications as, after consulting the authority, he considers appropriate, the Secretary of State shall by order make such provision for and in connection with the implementation of the scheme in relation to those elections as he considers appropriate, which may include provision modifying or disapplying any enactment. That is a broad and unqualified power on its face. It's triggered by the local authority submitting proposals for a scheme that falls within 10.2. Which, if Parliament had intended to constrain the power in any way, one could expect it to have done so expressly. Secondly, the nature of the power is an indicator that a broad construction is to be preferred. It's the power to conduct trials to acquire useful information about reforms to procedures, and its value as such is diminished if the purposes are narrowly construed. It's plainly intended to extend beyond schemes designed in the narrow sense to improve voter turnout, because we see, for example, that at 10.2b, the scheme could be a scheme about how the votes cast in an election are to be counted. It's a forward-looking power. It permits amendments to the rules from time to time existing, including rules that have themselves been introduced under Section 11 or amended. So it's unlikely that Parliament intended to constrain this by reference to a single purpose identified back in 2000. The pilots have got to be sufficiently informative to enable the Electoral Commission and the Minister to decide whether they're to be taken forward, rolled out under Section 11. And this requires a range of concerns to be considered, not just improving turnout. And the contents of the report, as set out in 10.7 and 8, which we're looking at towards the end of Mr. Pito's submissions, have got to be seen in that light. What they identify are a number of concerns which we can anticipate that the Minister, the Electoral Commission and Parliament would be interested in. Subsection 9 is also important because not only are those matters, the specified matters, not exhaustive, but Parliament's expressly provided for the Secretary of State to request that the report contains an assessment of such other matters relating to the scheme as are specified, which is a good indicator that the purpose of the scheme isn't being predetermined in advance. And then there's a point that I made this morning about 10.2a. There are absurd consequences if the appellant's right, because the rollout of a scheme that is directed specifically at increasing voter participation might reveal a security flaw, but on their Padfield purpose analysis, the Minister would not have power to pilot changes to address those security concerns. Our alternative case is that even if the purpose must be encouraging or facilitating voting, this can include piloting changes that are designed to do that in the longer term by improving the security of the ballot and public confidence. And as you've seen, these pilots were done for that reason too. I'm not going to take you to it, but it's EF 183 to 4, paragraphs 114 to 115 of our case. As to the appellant's arguments, by reference to the matters that are specifically identified in subsections 7 and 8, matters to be addressed in the report, then it put a lot of weight on the fact that the report should include an assessment of the scheme's success or otherwise in facilitating voting or in encouraging voting at the elections or enabling voters to make informed decisions at those elections. But we say that if Parliament had intended to limit the piloting power in 10.1 to schemes designed to improve voter turnout, it would have imposed that restriction expressly and directly in section 10.1, not given a clue that that was what they were interested in by specifying that was a matter to be covered in the Electoral Commission's report. As we say, it's unsurprising that those matters are always to be addressed, and they could, in an appropriate case, be addressed, as my Lord Sale said, by simply saying, for example, no, the procedures provided for by the scheme did not lead to any increase in personation. Not every question is going to be relevant in every scheme or it's going to give a useful answer in the context of every scheme. As to the extrinsic materials, we say broadly, case law shows that these are to be approached with caution. In any event, they're consistent with the Minister's case, as we've seen in the Howarth report, for example. There is discussion of the need to modernise electoral processes generally and to maintain public confidence. Then finally, and I think this is the note that I was trying to find earlier and had mislaid, we say that Hansard is inadmissible to ascertain Padfield purposes in any event. And of course that is Spathholm, and it's in the Authorities Bundle, Volume 2, tab 9, EF 2229.
Sorry, what's the page number again?
I'm so sorry, I don't know how I've done this. My page references seem to have gone awry. So tab 9 of the Authorities Bundle, and it's EF 2300, I think. Okay, starts at 2257. But could we pick it up at 2300 between letters B and C? It's a line, a sentence starting halfway through the line, beginning meaning of that expression. Here, the issue turns not on the meaning of a statutory expression, but on the scope of the statutory power In this context, a minister might describe the circumstances in which the government contemplated use of a power and might be pressed about the exercise of the power in other situations which might arise. No doubt the minister would seek to give helpful answers, but it's most unlikely he would seek to define the legal effect of the draftsman's language or to predict all the circumstances in which the power might be used, or to bind any successor administration. Only if a minister were improbably to give a categorical assurance to Parliament that a power would not be used in a given situation, such that Parliament could be taken to have legislated on that basis, does it seem to me that a parliamentary statement on the scope of a power would be properly admissible. And then a passage emphasising that the conditions laid down by the House in Pepper and Hart should be strictly insisted upon.
I wonder if I could just take you back to section 10, subsection 2.
Yes, absolutely.
I'm just doing so because I can't help feeling that there's actually more mileage in analysing the text of the statute. I'm just thinking about Mr. Pito has submitted, as I think he has to, that that it's permissible if you are changing the method of voting, if you like, the method of communicating your preference for a particular candidate. That if you adopt a new method which creates a real risk of identity fraud, then one can imply an ancillary power to address that. And he says, of course, your present case is different because it's not ancillary to something else. It's the primary objective of this scheme. And I'm just wanting to try to make sense of that submission in terms of subsection 2. Because we're told, the starting point is in subsection 1. What is all about is what's called a scheme under this section, which has to be submitted by a local authority or a local authority with the Commission under section 1A, subsection 1A. And then the purpose of subsection 2 is to define what a scheme under this section is.
Precisely. Yes.
And we're told that it's a scheme which makes provision differing from that made under the Representation of the People Acts as regards one or more of the following, namely, and then we have the list, and obviously we're concerned with A. So on Mr. Peters' submission, we have to, and said we can, read in something additional to this, that a scheme under this section can also include provision differing from that made under the Representation of the People Acts as regards, I suppose, any other, I'm just guessing, but one would imagine it might be any other matter, so far as it may be, what, necessary, appropriate, for the purposes of, or in consequence of, the provision made in respect of A, B, or C, as the case may be. If we're actually trying to find in the statute an implied power, or it's not really a power, it's an implied addition to the scope of what a scheme under this section is, we need actually to have a precise form of words in mind. Parliament hasn't legislated for this, but it's said, it's implicit in what Parliament has said, but that this additional aspect of the scheme is to be read in. And it just occurs to me one then needs to be able to work out what precisely that is, and one may, if one tries to do the exercise, have some problems in deciding what Parliament would have said if it had thought about this. But we can't have problems. It's got to be, there must be some sort of text which one could say is implicit here.
Yes, yes. And we'd respectfully suggest that all one does here is look at the language used and see whether schemes that make different provision for identification of voters are schemes falling within 10.2a, and they are, we say. And we don't need to read anything in. I think in reality what Mr. Pito's seeking to do is import a sort of Padfield purpose approach into 10.2. But 10.2 doesn't confer the power, it's simply defining the scheme.
Yeah. Yes, I suppose what I'm focusing on really is could these supplementary aspects of the scheme, the ancillary aspects, if you like, of the scheme, be as regards any matter covered by the Representation of the People Acts, or does it have a narrower scope? And when we say ancillary, what do we really mean by that? Do we mean that it's an unnecessary consequence of the primary change being made, or are we saying that it's a consequence, or is something which, I don't know, is reasonably considered appropriate, or what's the test, if you like?
Yeah. I think those are probably questions for Mr. Pito rather than...
Yes, they are. But I'm taking the opportunity to raise it with you, partly to give Mr. Pito time to think about his response, and if he does have something new he wants to say about that, then we may have to give you an opportunity to reply to what he says.
Well, I'm very grateful for that indication. I shall wait to see what he says about that. But I think it's probably not much help to you if I make any further points about Hansard, because I think for all the reasons that we've given in our written case, Pepper and Hart simply is not satisfied here. The case law is quite plain about what the conditions are, and they are to be strictly applied. And in fairness to Mr. Pito, he hasn't placed any great weight on it in his oral submissions. So I think what you might find helpful, most helpful, I know I haven't used all of my time, but is if I sit down now and don't just carry on repeating my key points for the sake of it, and allow Mr. Pito maybe to address the point that my Lord Reed's just made.
Yes, well, very well. Thank you very much, Mr. Vanessa.
Thank you, my Lord.
Well, you may find yourself on your feet a little bit faster than you expected, Mr. Pito.
Oh, yes.
If you'd like a few minutes to think about the point I raised, then we're very happy to allow you some time.
Much obliged. Might I just consult with my juniors?
Yes, of course.
My juniors suggest I take 5 minutes. That may be a good idea.
Yes, yes, by all means. There's no rush. We've got plenty of time.
Well, I'm full of admiration for the way in which my friend has gone through her submissions with, I think, 50 minutes to spare. It's amazing. But but thank you very much. I'll consider this point that you raised with her, and when we'll be back.
Yes, yes. Thank you. It may very well be a good answer to it. I'm just raising it because the point has occurred to me.
Much obliged.
Very well. We'll adjourn just now.
My lords, my lady, I'm grateful for the time. So, section 10. No extrinsic materials, just section 10. That's on page 1690. I'm going to answer your lordship's point directly. Only one preliminary point first is that section 10.1 and section 10.2, they are intimately related. My learned friend tries to make some division between them, but 10.1 introduces the schemes, which says that they may modify or disapply any enactment. But then it is entirely qualified by 2, which then says a scheme which makes provision differing in any respect from the Acts, the Representation of People Acts, then it is cut down as regards one or more of the following. So there's no question at all that there's any generality lying behind Section 2. The schemes are defined narrowly in A, B, and C. Now, if it had been intended by Parliament to have a general power to try out different rules about elections under the Acts, then the words could simply have stopped after the words Representation of People's Act in subparagraph 2 and not carried on with as regards one or more of the following. So clearly, 10.2 is designed to tether the power to these words in our, we can say when, where, and how. Now, directly, my Lord Reid's question, I don't submit that any additional words should be read into this provision. Simply rely upon the words of Parliament. As I've submitted, we submit that the word how takes its dictionary definition of by what means or manner, and that voting takes its definition as being the communication by a voter of the chosen candidate to the enumerator, so that the proper construction on its ordinary language is, when it says how voting at the elections is to take place, is the changes has to be, it says it has to make provision which is different from the old provision in the manner or means by which the voter communicates their choice of candidate. Now, if that's to be changed, and this is now, I think, the kernel of what my Lord Reid was asking, is, so what about this? We have a change within that definition which says that you can vote from a computer at home or in some other place by pressing keys which then identify to the enumerator your choice of candidate. Now, if you do that, you've changed the how within that definition. But without adding any words at all, it is obvious that the person pressing the keys has to communicate also what name is to be ticked off the register by the officer, or the enumerator. And that doesn't require any extra words, because that is just so obvious. Now the question is, next question would be, that really answers the question. The next question might be, well, what kind of means of communicating the name to be taken off the register as having voted can the Secretary of State lawfully impose once, if and only if, there has been a change in the way in which the voting choice is communicated. And that would be this, really. I don't submit that once there has been a change in the method of voting, that the discretion of the Secretary of State then is constrained by any words other than those one sees in 10.1, at the last line, 10.1, where it says Secretary of State may make such provision for and in connection implementation of the scheme, that's implementing the scheme of changing the method of voting, as he considers appropriate. And those are the words there. And of course, that then answers, I think, my Lord Reid's question in terms of the construction of this provision. And I stress yet again that these powers only come into operation once there is actually a change in the means of communicating the vote. Then these powers come into operation. These modifications, disapplyings of statutes. Of course, then, if this is not a question for the court today, but hypothetically, if one then were to get some new scheme of voting by computer, by telephone, where there was some improper or unreasonable condition attached to that, then that would be attacking the words as he considers appropriate, and that would then be a Padfield or a kind of a Wednesbury-type challenge, but that doesn't concern us today. What does concern us today is that in my submission, because there has been no change in the means by which a vote is communicated, no change by doing it by phone or by computer or the like, it means that the minister doesn't get to base one, so to speak. So he's not entitled, or she at the time, to bring in these unauthorised changes. And Lords,
just have difficulty in understanding. You say it's so obvious that if you have a change, that you have to have identification. Is that right?
well, you have to communicate to the officer the identity of the voter, so that the officer can then cross off that name on his list, which is what happens now. That is
Well, you could do that without any voter ID. You could just say, I'm Joe Bloggs.
on remotely.
Yes.
But that you could, but that would then be a matter for the. Well, you couldn't say it in the same way as the present rules, where it's a verbal communication to an officer across the desk. You might say you could do it by phone. And one of the things that was considered was the idea of voice recognition. It could be by phone. It could be by seeing where the computer is situated. I mean, I'm making these things up, it all depends. It could be by being given, as I think in one scheme, in advance a password number, which then you enter. It could be by facial recognition on a computer. It could be by using a thumbprint. It could be by, I mean, these are all things which, once you have a different voting system, then there could be, then there's a power to try out different ways of the voter communicating their name and address to the officer, so as to then be registered as someone that has voted. So that can change. But the point is that's when you actually changed a method of voting, of actually communicating, then that all has to come in. And it comes in as the minister thinks appropriate. I think the expression is, as he considers appropriate. So the problem here for the minister is there's been no change in how one communicates a vote. It's been used for an extraneous purpose. Thus, for the language of the statute, and we submit that that's on the natural words, and then a friend we take issue with the idea that there was a general power, because section 10.2 cuts that down to these words of when, where and how, or the other schemes for counting voting or encouraging voting by communications. But that's on the sheer words, which I think is what my Lord Lorry was asking about the wording. But I don't resile from the purpose of construction. And if one looks at the rest of the words, were the words about, you have to answer the question, if you're doing the report, did the voters find that the procedures provided for their assistance were easy to use? And that, along with the words of facilitation, do in my submission give the Minister and Parliament and the courts as well what the thrust of all this was. And this scheme doesn't provide any procedure to assist anyone or to make anything easier for a voter or the voter. This is for the voting question. So that's purposive. But my Lords,
So you don't rely upon the implicit argument that you were putting forward before. It all depends on what the minister thinks is appropriate.
once he's effected a change in the voting.
So it's not implicit in
No,
that argument's gone, has it?
With the assistance of my much more learned juniors, yes.
That argument.
I'm not saying. I think, my Lord, I'm saying I don't need that. It's within the words. Sorry, my Lord.
No, not at all. I'm sorry, I was interrupting you. So if you introduced, for example, telephone voting, and there was some, evidently there would have to be some system to establish who was doing the voting, voice recognition or whatever, would that form part of the scheme?
Yes. It would be. It does, because the essential feature of the scheme is to change the method of voting. In your Lordship's example, it's by phone. Then, you're into a scheme, that's intra vires as long as it's not improper or something. It's intra vires if it's done properly for the purpose of facilitating voting. Then that scheme can have such changes to enactments.
Well, you say that, you see. I mean, that's what I'm wondering. I thought that was what you were meaning. So you say the scheme is to introduce telephone voting, and under 10.1, if that's proposed and approved by the Secretary of State, the Secretary of State shall make such provision for and in connection with the implementation of the scheme as he considers appropriate. And those are the words that would cover the, particularly, this hypothetical example, the voice recognition system. So it wouldn't actually be part of the scheme, but it would be part of the, it would be a provision made in connection with the implementation of the scheme.
Yes, I suppose that's right, yes.
Mm-hmm. Now, if that's right...
I think that's right.
Then when you come on to the reporting, the starting point under 7 is that the report shall contain a description of the scheme and of the respects in which the provision made by it differed from that made by or under the Representation of the People Acts. So that would all be to do with the use of the introduction of voting by telephone, but the voice recognition system wouldn't be part of this description of the scheme and wouldn't be one of the respects in which it differed from that for which the scheme differed from provision made under the Representation of the People Acts.
One couldn't really... This provision says it shall include the following. So it would have to include, of course, the voice, the telephone system. But it doubtless would also include a description of the voice recognition.
Mm-hmm. Yeah.
I mean, it would... This says, these are the things which have to be within the report.
Yeah.
But of course, it says in particular contain, although that wasn't there at the start. It's... the truth, it's... one couldn't really describe the scheme in full for it to be properly tested or properly appreciated or properly understood by the Electoral Commission or by the Houses of Parliament unless one had that voice recognition part of it.
Yes, well, that's what I rather think. And in that event, relying for vires purposes on the words at the end of Section 10, subsection 1, isn't going to work because that's taking the identification system outside the scheme.
Well,
but if it's part of the scheme, then it has to come within the how is a point in 2A, I think, doesn't it?
Well, it seems that it's one thing which is inevitable as part of any part of voting, I suppose, is the ability for the officer to tick off the name. Mm. And that's something, and by the way, my Lord, I'm not necessarily resigning from the implicit. This is my primary submission, but my primary submission is all within the words. But there's an aspect of interpreting statutes in a way which is in accordance with common sense and not absurd. I think it used to be called the Golden Rule, I'm not sure. But here, considering the statute is a matter of common sense, if you're going to have a different way of voting remotely, then it is blindingly obvious that there's going to have to be a different way of communicating the identification of the voter than just by across a desk. And that's so obvious, I think one can assume that that's, whether one uses the word that my Lord used about implicit, which echoed a word I used, whether one says that it's just within the construction, as a matter of construction, it's there. It has to be there as a matter of construction.
But, I mean, just going back to the structure of Section 10, these schemes are supposed to be put forward by a local authority. They're the body which is supposed to come up with the changes, which they then suggest to the Secretary of State. Well, it would seem, just so I can put it to you, you can come back. It seems very odd that voice verification in my Lord's example wouldn't be within the scope of the scheme as proposed by the local authority. I mean, surely the whole package is proposed by the local authority and is the scheme.
What seems to have happened in practice, I don't disagree with your lordship about the way that this section is laid out, but what seems to have happened is central government has invited local authorities to agree to schemes that they've proposed. Then the local authority can come forward, and I think that's what's happened with these pilots, is the Cabinet Office or the Minister for Constitutional Affairs invited local authorities to agree to participate in these pilots, which I think the Minister had described in some detail exactly what they'd, or pretty closely what they'd be.
Right. I mean, that may be what has happened here, but I'm just looking at the structure of the provision, which seems to be based around initiatives from the local authority, presumably on the theory that local authority are close to the ground, have a sense of how the voting system may be working, concerns that may exist in their area, and then they can suggest modifications which can be run as the pilot. I'm just putting to you that it seems strange to strip out from that what, well, in my Lord's example on the voice verification, one would think would be absolutely central to whether the scheme's going to work or not.
Well, I would respectfully agree with that. It's
so voice modification wouldn't be implementation; it would be part of the scheme.
Yes.
Yeah.
Because
and other forms of voter ID would also be part of the scheme.
Yes, my lord. So long as the scheme involves a change in the method of voting, then yes, the Secretary of State, part of the scheme is then how one communicates one identification. But not just by itself. Because if you're just going to have exactly the same means of voting as you've always had for 150 years, and then add on a requirement for producing papers, that isn't then a scheme within this Act because it hasn't changed the method of voting. That's my submission.
Well, if voice recognition is part of the scheme for a change, it's part of the scheme because it's how, isn't it?
The how is the
communication.
Sorry, the how is the communication. I want to vote for logins on the telephone. Yeah. I'm doing it by telephone now. I'm not doing it on paper. Right. Okay. But once you've got that change, then of course you have to have as part of the scheme how you say who you are. That's my submission.
I'm sorry. To just go back to the implicit argument, I understand you're still relying on that. Implicit in what? In the legislation or implicit in what?
Well, it's in the legislation because it's, I could say it's a matter of construction. I mean, it's when the courts construe legislation, of course, they have to construe it with a broad dose of common sense. And here, on its true construction, as is formed from your lordships, if there's to be a change to remote voting, which is a change in method and therefore how, there has to be a change in how you tell the officer who you are. And that as a matter of construction must be right. I mean, it's not really asked, it's not a very extravagant submission, my submission that. This is just the application of ordinary common sense.
Now, Mr. Beattie, I appreciate you'll want to cover some other points before you conclude your reply. But I think I ought to let Ms. Giovanetti respond on this point because it's essentially a new point that's being made. Ms. Giovanetti.
Well, could I firstly respond to the suggestion that in order to have a broad construction, or if Parliament had intended a broad construction, it would simply have had a full stop in 10.2 after the word representation of the people acts. Okay. But of course, if you had that, if you just look at it without the as regards one or more of the following, that would cover eligibility to be on the register, for example. A local authority might want to trial reducing the voting age to 14, or and that's not what it's about. The reason that you've got A, B and C is to make it plain that it's about the processes and procedures to be followed at elections and not by the substantive right to vote. There are essentially two alternatives. One is to interpret when, where and how voting at the elections is to take place the way that we suggest, which is to cover those processes and procedures. And if that's the case, all of that falls within the scheme. The scheme isn't just a scheme which includes different provision of that sort. It's a scheme under this section, is a scheme which makes different provision, not which includes it. And all of the different provision is to be included, is to be in the scheme. All the changes that the scheme makes to those procedures should be in the scheme. And it's a clue to that is that it's not just that the local authority proposal is supposed to be a proposal for the scheme, but if you remember, we looked at 1A, and if the proposal for the scheme isn't submitted by the local authority jointly with the Electoral Commission, the Secretary of State's got to consult the Commission before making an order. What the Commission's being consulted on is the scheme, not the sort of ancillary adjustments around the edges.
And I just looking through Section 10. I mean, Section 10(6), it says the Electoral Commission shall prepare a report on the scheme. It would seem very strange that they wouldn't be reporting on, the nuts and bolts of how it works, because the nuts and bolts are going to affect whether it's a good scheme or not.
Yes. Yes.
And also, for what it's worth, I was looking at the original provision as enacted, and it used to be, I think, the local authority that reported on that, presumably,
before
on the basis that, again, they were close to the ground. They would have a sense of whether it was working on the ground or not.
Yes, precisely.
And again, one might think that takes you back to the scheme, including the nuts and bolts of how it works.
Absolutely. I mean, and that, of course, was a position before the Electoral Commission was established. It was about a year, I think, after the Act was introduced. Our construction is much clearer and more certain, we say, and it doesn't hive off what are really quite important aspects of the scheme into the sort of ancillary provisions in connection with the implementation of the scheme, which are dealt with in the final couple of lines of 10.1. So our provision is more faithful to the language. It would seem very surprising if Parliament intended what is in reality part and parcel of the scheme, not to be within the scheme, but to be addressed by the Secretary of State under the rubric of such provision as he considers appropriate in connection with the implementation of the scheme.
And what are the provisions that don't include, modify or disapplying any enactment?
Which don't include?
Yes. The Secretary of State shall by order make such provision for or in connection with the implementation of the scheme as he considers appropriate. Okay. And then you have...
Which may include.
Which may include.
Yes.
What are the other ones?
I can't think of any examples off the top of my head. I think if I combed through previous pilot schemes, one might see sort of administrative things such as, I don't know, needing additional attendance at the ballot, making provision for checks by the Electoral Commission, allowing for access, etc. But they are going to be very much sort of ancillary and not properly part of the scheme itself. I think those are the only points we made, which we hope would assist the court.
Thank you very much. Yes, Mr. Peter.
I think just to clarify, a scheme has got to include a means of allowing the officer to know who you are so that he ticks your name off, to make that clear. But I reiterate, probably the umpteenth time, that it only gets into being a scheme if one's changing the manner of voting itself. Then, as a matter of construction, a different way of communicating to the officer who one is, so one is then ticked off the register, comes in. Learned friend said that it was clear that these provisions were only about voting procedure, and not about other things, other rights like registration or secrecy that might be affected. That, of course, is narrowing down quite considerably the test that was put forward by the Court of Appeal and the Divisional Court, which seemed to think that anything in the electoral landscape could be tried out. So if we're just talking about procedure, and also it's, since the Minister accepts the experimentation in process and procedures is what it's about, that still doesn't allow there to be a change that would determine a downward change in whether one can vote or who can vote, which is what this scheme does. And also, before going to one or two points of detail, I don't want to lose sight of the overarching point which really this case is about, and that is the constitutional argument. Now, it may be that the Court of Appeal said it was a very important right. They didn't determine the issue as whether it was a constitutional right. But whether one calls it that, and we submit it should be a constitutional right, it's true that one has to look at all the institutions of the country to see what amounts to a constitutional right. And I would then adopt again respectfully the way that my Lord Sales put it extrajudicially in his article, that one has to look at the country's constitutional tradition, its political practice, and its self-understanding. Now, one thing which your Lordships will have noticed is nothing that's fallen from a learned friend or from the Minister deals with this major change in the landscape, which is putting the interposition of an unelected and unjudicial, unqualified officer between the voter and their ballot. Because they can say, I'm not satisfied with these papers, I've got a doubt, a reasonable doubt about the paper, and then they've got a duty to ban you, and you've got no recourse except by an electoral petition, which of course doesn't restore your vote, only works if it makes a difference to the result. I don't flinch from this submission that on the approach that my Lord Sales takes, and I would respectfully adopt, is in deciding what is constitutional in this country without a constitutional document, one looks what is our constitutional tradition and our political practice. And for 150 years, since 1872, that has remained unchanged for local and parliamentary elections. It has been a part of our landscape that we don't have identification cards compulsorily in this country, which marks us out from most other democracies. That's been a matter which of itself has been a matter of deep controversy, but the tradition remains as it is. If we had a country where we had compulsory identification, we wouldn't be having this case. Everybody would automatically have a card. This wouldn't be a problem. But part of our constitutional tradition is that we don't have that. Now, that may change, but at the moment, that's how it's been. And that's reflected in the fact that for 150 years, our political practice has remained constant, as has the constitutional significance attached to this. The 1872 Ballot Acts were profound. Followed after the Reform Acts, which at least extended the franchise to male householders. But these traditions predate the time that all men were allowed to vote, irrespective of being householders, in 1918, and predates by even longer the time that women were allowed to vote, or all women, not until 1928. These are obviously deeply now embedded in our constitutional tradition, that all men and all women can vote irrespective of property. But this tradition predates that. So it satisfies that. It's something, the idea of going to vote without the interposition of an officer who may use a prejudice to arbitrary or capricious judgment to deprive the voter of their vote, something that we've seen in other countries being abused, is something we've kept out so far. There's no allegation here, of course, that that was what anybody had in mind. But this is the impact or the effect. Now, I would submit that going to the polls in the way that people in these islands have done for 150 years, and you go along and you confirm your name and address, and the officer, you have no fear from any officer. No officer can stop you voting. No officer can interrogate. That is something, if that is not embedded in a constitutional tradition or political practice, or part of our self-understanding as a people, as we are now, this is something which is deeply ingrained, I would submit, in the soil almost of Great Britain. It's the kind of thing which we can be quite sure, if Parliament, if the MPs had known that this vista was something they were opening up, then that would have caused some stir. But the point is there isn't a whiff of this in anything which the Crown has put before this court. There's not a whiff of any of it. No one can doubt, surely, that this would not have provoked controversy. I'm not suggesting that this court is the place, or that my argument is the place to deal with whether or not the controversy is one way or the other. But this surely is a constitutional controversy. Nothing that the Minister has said has dealt with this issue about the interposition of the officer with the subjective judgment and the voter. They've said nothing about that. And they can say nothing about that, because that is simply contrary to our constitutional tradition. And that engages, I would submit, classically, the doctrine of legality. This is precisely the kind of thing which has gone unnoticed in the democratic process. And had it been noticed, had it been written there in full, this power will enable us to have a documentary requirement on voters. They will have to prove their entitlement beyond all reasonable doubt to an officer on the desk. Had it said that, then who knows what the outcome would have been if Parliament had voted on that. It's precisely so. This court, what we're asking the court to do is to uphold Parliament's supremacy. It should have decided this. This should not have been something dreamt up by a minister many years after the power was conferred for a purpose which no one, and I'm sure that no one in this room can think that that was envisaged by the words of this statute or indeed by the background papers or anything. That remains, and because the impact, and I haven't been able to have time to go through the details, but it's there in our written arguments, because the impact, I've mentioned that before all voters, the impact has been on their right to be on the register simply on the balance of probabilities, and now de facto they have to prove their entitlement beyond reasonable doubt. But without the ability of an appeal, at least beyond on the balance of probabilities, you had time to go to a county court judge and have the courts decide. Here, it's simply an administrative decision on the spot, and you can't do anything about it. Those are the two, but of course, if one looks through the documents that have to be provided, one finds there's many people who will find that difficult or find that restrictive. There is evidence, I mean, for example, that there's a large disparity in the number of BAMI people that have, I think 48% have got, I think we've got driving licenses as opposed to 76% of white people. There's many examples like that. But generally, this is the kind of thing which our submission to this court is, this is what Parliament should have decided. And as my learned friend said, the point about the principle of legality is it's supposed to be a tool to assist the court in deciding what Parliament's intentions were in an act. But just as importantly, it is just to also determine what Parliament probably never intended at all. That's really that's really the purpose of the rule. Is this the kind of thing that there's a risk that Parliament never intended this, didn't see it coming? I respectfully agree with my learned friend when she says that maybe the test is this a startling consequence? And in my submission, yes, this is a startling consequence. Startling consequence for us all, a damaging one for some. In the end, a damaging one for us all, because if we're in a system where some can't vote, then surely none of us are free. Because we can't be any sure, again, that the voting will command that kind of respect. Unless I can assist further, my lords.
Thank you very much, Mr. Peter. Well, we're obliged to counsel and those sitting behind them for their assistance. We'll now consider the arguments that we've heard, and we'll let you have our judgment in due course. The court will now adjourn.